Yes.
My lord, may I be permitted to mention one
Sorry, sir. Come on Monday. Mentioning on Monday and Thursday.
restoration application?
Monday. Yes. Call the list.
My lord, in this matter,
For the
I was
Mr. Ranjan Bhattacharya.
I was made party in the tribunal as private respondent. Perhaps I am also party in this WPST.
You have not been made a party.
Perhaps I am. They have made me a party. But no
What is your
copy.
client's name?
Actually, my lord, copy has not yet been received by my client. So I'm
That is a
different
different
to
thing.
supply
That
me a copy and fix it at
Say that it does not mean Shamim Mullah.
Well, I am appearing for the state government.
What is the matter about?
May I tell your lordships?
Matt.
May I tell you short for?
Clear, my lord. There is a dispute between husband and wife, and several
Lordship
criminal.
already passed an order regarding the matter, Lordship. Then we go to the tribunal, Lordship. The tribunal has dismissed the
May I tell your lordship the short for?
The private parties and the wife approached before the tribunal since the husband selected in the West Bengal Civil Service examination, his selection be cancelled due to pendency of civil and criminal proceeding before the court bill. But the tribunal holds this is a private dispute, so we.
Yes, then what?
Lordship, kindly see the page number 32. Lordship order, Lordship.
Yes.
The same order, Lordship, the tribunal only dismissed the same matter, the personal dispute, Lordship.
Where is that?
Lordship, the order also they added last page,
Where
Lordship.
is the order of the tribunal?
Kindly see the order.
Just give us 2 minutes.
Page, Lordship, last page in
We got it.
13th of October 2023.
ये बोला
আমি বলে দিচ্ছি
এক লাইন বলে দিই
আমি বলে নি আমি
If Lordship,
জুনিয়র আপনি তো বলবেন
apology, Lordship.
আমি জুনিয়র একটা লাইন বলি আচ্ছা ঠিক আছে আমি 15 যাবেন না কিন্তু দাদা
না 15 যাবে না আমি দেখিয়ে দেবো
একটা বলেছি ট্রাইব্যুনাল অ্যাপ্লিকেশনটা কিন্তু সেকশন 15 করেছে সেকশন 15 ট্রাইব্যুনাল অ্যাপ্লিকেশন লাইক হয় না ইট উইল আর আন্ডার 90 ট্রাইব্যুনাল অ্যাপ্লিকেশনটা দেখুন সেকশন 15 এ আছে
প্রসিডিওর জুরিসডিকশন
প্রসিডিওর অ্যাপ্লাই না করলে আমি ঢুকবো কি করে ট্রাইব্যুনালে
না না ট্রাইব্যুনাল অফ জুরিসডিকশন নেই
ট্রাইব্যুনাল জুরিসডিকশন নেই আর অ্যাপ্লিকেশন ফাইল করেছে ট্রাইব্যুনাল অ্যাপ্লিকেশনটা ফাইল করেছে সেকশন 15 এ দেখুন ট্রাইব্যুনাল অ্যাপ্লিকেশনের টপে সেকশন 15 লাইক মানে গৌতম দার নামটা দিয়ে দিচ্ছি
You didn't show the High Court order to the
Yes,
tribunal?
Lordship, I already showed the High Court order, but they did not.
High Court's order is wrong, totally wrong. Kindly see section 2Q.
Lordship,
Of the
kindly
administrative-
because they did not receive the copy, so kindly fix the matter another day, Lordship, because this is my request because they.
Who passed the wrong order? We passed a wrong order.
No, High Court passed a wrong order.
Yes.
Kindly see section 2Q of the administrative order.
What is that? Tell us.
Service matters. Means a service within or outside India. Service matter in relation to a person means all matters pertaining to the condition of his service. Of his service. But the applicant must be the state government employee. The applicant is not a state government employee. Am I wrong? Clear to your lordship? The applicant before the tribunal must be an employee of the state government or central government. His service, his or her service. He is not she is not an employee of the state government. Accordingly, the tribunal has no jurisdiction to go to the dispute. There is a dispute between the husband or wife.
Then where he will go?
He approached the High Court. He could have ordered passed for the letter before the division bench.
civil court, appropriate civil
Civil court
or criminal court.
Criminal court. Criminal court trial is going on. The gentleman has been selected by the state government as an employee of the state government. He is serving. His contention is that
Petitioner is a school teacher, Lordship.
Simply, minor, it
The
is a
housing
case of
is
third party interference. Simply, it is a case of
Please,
third party
please,
interference.
please.
but if somebody
School
today
teacher, Lordship.
That you did not tell us.
Already kindly I annexed the document in the tribunal application, original application, Lordship. Page. Yes, Lordship, page 18, Lordship.
No,
I
no,
already
what was the writ petition about? First writ petition?
first retribution we did not advocate recording the matter, but then we see the order regarding the dispute. There's a private dispute. The retribution said. Then we file an appeal application before you, Lordship. Lordship pass an order. Then we go to the tribunal. But tribunal same thing that this is a private dispute. Lordship.
But the tribunal decides service matters, na?
Yes, Lordship.
Yes,
So you are an employee of a school.
school,
I'm the
teaching.
employee of school, but my husband is a state government employee, Lordship. I already explained in the original application.
You are the wife.
Why?
Lordship, I'm the wife, Lordship.
So you the writ petition was filed by whom? By the wife.
Wife.
By the wife.
For what?
For regarding my husband appointment, Lordship.
How he has got a right?
Third party.
How he got, what locus
How
standa he has
third
got?
party, Lordship?
What locus standa he has got?
It's hard. Where is Anjan Bhattacharya?
Lordship, my senior English to courtroom 13 is item number 1 in the personal appearance in contempt matter, Lordship.
Very good.
Page 20.
Ask
Ask
him
the
to
word.
come.
Page 20.
My lord, make it on next week any date because I am
No,
not
no,
with
this
I'm not
order-
with the writ petition, my lord.
This order was passed by myself and my brother.
Yes,
So it needs to be heard by us.
Certainly, my lord. But
But on Monday, my brother would not be with me. A new honorable judge will be with me.
order of division bench.
yes, other division bench. Page 32, Lordship. This Lordship
So
order,
the
Lordship.
wife preferred a writ petition challenging the appointment of the petitioner who is a school teacher.
No, Lord, petitioner, husband, Lordship.
Husband who is a school teacher.
No.
No, Lordship, I'm the school teacher. My husband is a state government employee, Lordship.
Oh,
This is called review application, my
will you keep quiet? Have we asked you? Please take your seat. Please take your
I'm
seat.
paying.
No, please take your seat. Where from you people develop this practice, we don't understand. স্কুল টিচারটা কি স্কুল টিচারটা কি তাহলে ও বললো যে আমার হাজবেন্ডের সার্ভিসটা অ্যাপয়েন্টমেন্ট লেটারটা ক্যান্সেল কর মহিলা স্কুল টিচার but he's challenging the
appointment of her husband as
who
a
happens to
review
be a government
of
তাহলে why did the tribunal dismiss আমার jurisdiction নেই বলছে কেন?
In the High Court, only writ of querent will be applied. No other. Tribunal has no jurisdiction to issue writ of querent. If writ of querent he paid for, then
Lordship, why
High
am
Court has got jurisdictions.
Lordship, why I'm challenging the appointment of the husband? Because Lordship, my husband is facing some criminal cases, Lordship. If the criminal is a state government employee,
Point is not there.
not that.
You are a school teacher. Who can approach the tribunal? A person who is in state government service. A person who is in state government service can challenge the first court said that it is a private dispute. In appeal, we modified that saying that private dispute issue has to be eliminated. Now you go to the appropriate forum to challenge the order of appointment of your husband.
yes, Lordship.
Now, the point which the tribunal takes is that administrative tribunal as gives jurisdiction to the tribunal in respect of an incumbent's service related dispute. You are a teacher. It is not a dispute as regards your service. It is a dispute as regards the petitioner's service. So this you want setting aside appointment of the petitioner.
No, no, I'm for the petitioner, Lordship.
For the husband.
Husband, Lordship.
Husband.
Husband.
Lordship, if Lordship pass over the matter, so I can inform my senior, so he can appear the matter, Lordship.
All right, complete service.
Lordship, kindly fix the matter.
Further points.
Lordship,
He
kindly
did
fix
on
the
next
matter.
week.
PM,
He
Lordship.
did on next week.
When for the first time I got this point, when I have searched all the judgments of the Supreme Court, when at this point has not been dealt with seven except L. Chandra Kumar. L. Chandra Kumar have brought, I have seen that L. Chandra Kumar said, if an employee of the central government or state government has any grievance, go to the tribunal. As a first instance, because tribunal constituted under 323A. His service conditions. Applicant must be a,
No, no, not suppose today.
or I participated in the selection process. If
For instance-
my landfront clients participated in the selection process, her husband was selected, she was not selected.
Give me the book. 2Q. এই administrative tribunal একটা দাও।
2Q.
Cookie will not be answered.
In relation to a person বলেছে।
ওটা হচ্ছে সাবজেক্ট ম্যাটার, যে সাবজেক্ট ম্যাটার অফ দ্য লিস্ট, কিন্তু who can any percentage will extend the third party will cover the third party or not?
না, আমি তো কি পাইনি।
এইখানে সেকশন 19 এ
WPSC তো পাইনি তো।
by an order
By an order pertaining to any matter within the jurisdiction of
ঠিকই বলেছেন। একদম।
Mr. Mukherjee kindly comes to section 19.
Yes. When a section 19 is a procedure for filing an application. And
Who can file?
who can file?
this is the question.
Question is who can file?
Who
Your
can file?
argument is it is not a relation in terms of service matter of the applicant.
Applicant.
We understand that.
Yes.
One contention is for challenging that appointment, he can pray for issue of quo warranto.
Only warranto.
Now kindly come to section 19.
Didi,
You have a book?
Yes, sir.
Subject to the provision of a person agreed by an order pertaining to matter the jurisdiction of the tribunal make an appearance for the.
Agreed by any order pertaining to any matter.
Yes.
So he can challenge any order pertaining to any matter which is jurisdiction of the tribunal. What is the jurisdiction of the tribunal? Service matter of government employees.
Service matter of the government.
Now, a person aggrieved by any order pertaining to any matter within the jurisdiction. So the petitioner applicant is aggrieved by not an order, but an incident of appointment of her husband who is in state government.
But your lordship can say.
Please assist us.
Yes, sir.
As you have, L. Chandra Kumar says that it is the court of first instance, wide jurisdiction, etc., etc.
That's,
Our question is, please assist us.
Yes.
That whether this any person who who raises a dispute pertaining to a service matter of one person,
Another person.
of another person.
can he come on?
Yes, but just but I have applied for the post of ex post. My husband applies for the same post.
We
are not
understand that
selected.
he is not of the same selection.
Same
procedure,
selection process.
But we have to check it out.
Whether any person will include third party or not.
No, not third party.
It is the question to be answered.
Yes, that answer has been given to section 2Q.
Okay, yes, come.
Q to
Service
subject
Service
of
matter.
It is not the locus.
No.
It is subject matter before the tribunal.
Subject matter, no.
is what is service matter?
Service matter.
In relation to any state government employee or who is holding a civil post.
That means who can approach the tribunal? Only the government employee or the person seeking government employer or a third person
Yes.
claiming something irregularity in appointment of others.
But that jurisdiction has not been conferred by the tribunal.
No, we want to.
Find it out.
We have to search out there.
Last night.
You also find it.
And
It's an
may I come to
interesting
one thing, my
point.
lord? The petitioner invoked the jurisdiction of section 15 of the Tribunals Act, not section 19. My lord, kindly please, the original application,
Already annexed the
Page
jurisdiction lordship.
original application,
Original
before the
application,
tribunal,
but not at page no, but at
Section 15.
15.
15.
They invoke the jurisdiction of section 15, not 19. একদম সামনে আরেকটু যান,
No, no.
এদিকে যান।
Jurisdiction. That
All
is the
service matter concerning a person, not
The
being
15 is
person
the jurisdiction of the tribunal.
Mhm.
It is not the gate of entry of the tribunal.
all jurisdiction powers and authority exercised before the by all courts exception recruitment and matters concerning recruitment to any all service concerning a person all service matter not being a person referred to in clause C of the subsequent
না না এটা না ট্রাইব্যুনাল কপিটা
Tribunal copy. Oh, tribunal.
এই যে,
Yes.
এই তো এটাই তো। My lord, kindly take table page 4 para 4 এটা পেজ কত পেজ
এটা
মার্কিং
তো দেখি
মানে kindly see page 4,
না না
paragraph
page
4,
না না হবে না পেজ মার্কিং নেই এখানে
আবার
kindly take up the tribunal application
original application.
original application
No page bar has been.
page marking করা নেই। মানে how the it is a certified copy original certified copy
paragraph 4 of what which paragraph 4 you are saying
4 of the original
4
application.
of the original application
Application filed before the tribunal.
which was filed before the tribunal. He invoked the jurisdiction of section 15 of the Administrative Tribunals Act, not section 19.
no jurisdiction
Jurisdiction conferred under section 15. Procedure is section 19.
Procedure is section 19.
jurisdiction where you are the person who can what is your authority that is jurisdiction that is service matter etc civil
ওইটা তো।
yes Mr. Bhattacharya
Yes.
you are a school teacher
Yes.
you are challenging the appointment of your husband who is a state government employee. Now whether a person who is not in government service according to Mr. Mukherjee cannot approach the tribunal your remedy would have been to seek a writ of quo warranto before this court. So show us any document or any provision by which defines the person who can approach.
But that is there.
Where?
I have annexed it, but the kindly sees but the Administrative Tribunal Act.
Yes.
Section 3. But I was not there, but I was before Justice Mantha in a matter, contempt matter.
Why do you name the judge? Where we are not interested.
No, but
You can be in your chamber, you can be before the Chief Justice. Why
Kindly-
do you name the judge?
but kindly
I was before Justice Mantha. So what impact does it have?
that your
Why
lord
do you unnecessarily mention names we do not know? My lord, I was before that honorable judge. Did we want you to know? Did we want? When you people will learn? How many years of practice? Already 25?
24. Well, kindly do not take in that
No, no,
fashion. Well,
this
kindly,
sort of submission irritates us. Are we concerned whether you are which court, who is the judge? Never. This practice is deprecable.
well, your lordship.
Yes,
Well,
tell
this
us.
is a matter, well, where, well, what is the ground of challenge?
First tell us your locus to approach the tribunal. That
Well,
you can-
kindly give me 1 minute, time minute, so that I can appraise your lordship, and in other way, then I will come to the act. Well, my first writ petition before this court was moved before one of the learned single judge of this court. But kindly sees the order of the learned single judge once, then Marat, the division bench's order passed by this honorable bench.
learned single judge says go to the administrative tribunal.
Yes. This has been done. Number the learned
There
single
was a statement that it is a private dispute.
true,
In appeal, you came only on that ground of private dispute.
true,
The appeal was limited to that.
true.
We said that no, if you, before decision of that matter, if you say it is a private dispute, then you will have no avenue to approach the tribunal or whichever forum.
Tribunal.
Now
The word says tribunal.
Uh-huh.
The word says tribunal. Yes, yes. But kindly, Ballot turns to page 33 once. My this bench's order.
Page not mentioned.
Page mention কর।
Yes.
Number internal page 2 of the judge. এটা তো certified copy আমি করে দিয়েছি। সেই জন্য page mention পুরোটি।
তার তো page
পুরো
mention
পুরো অ্যাপ্লিকেশন
পুরো রিটটাই ওইটাই certified copy লাগবে। From the, got it? Internal page 2. From the impugned order. From the order impugned, it appears that the learned court did not go into the merits of the writ petition. However, the writ petition was held to be not maintainable since the dispute, according to the court, was private in nature. It was also observed that since the appellant was challenging the recruitment process of a state government employee, he ought to have approached the learned tribunal. This is the observation of the Honorable First Court. In our opinion, having held that the writ petition is not maintainable before the High Court, as the challenge was pertaining to a recruitment process of a state government employee, the learned court ought not to have observed that the dispute between the parties was private in nature, and that too without going into the merits of the case. Then, in view of thereof, the order dated 17th August 2023 passed in writ petition number so shall be read excluding the observation that private dispute private in nature. The order dated 17th August is accordingly modified. Number, your lordship did not touch that portion to approach the tribunal.
That was not the ground in
Absolutely not. Number, that remains, the High Court order remains. This is number one. Second is, your lordship kindly have a look to.
No, we understand, Mr. Bhattacharya. We are wanting to know the answer to a point which has been raised by
Absolutely, but I'm giving answer to page 24.
24.
But this is the Administrative Tribunal Act,
section 15 of the
section
Administrative Tribunal
15.
section 15 of Administrative Tribunal Act
But it is
ওটাই annex করে
annexed.
দিয়েছি, ওটাই annex করে
This section is annexed. Xerox copy is annexed. Page 24.
That is not telling with us.
It is not telling with us. Well, this is
No, the act is there, act is there.
the act. Is there. This is the act.
বই আছে উপরে, বই আছে। বই দিয়েছি।
Jurisdiction, power, and authority of the State Administrative Tribunal.
হয়তো যেটা পাস করে ঠিক আছে নামটা ঠিক আছে নামটা
Yes, section 50.
15. Now, kindly have a look to 1. Save as otherwise expressed, provided in this act, the administrative tribunal of a state shall exercise on and from the appointed day all the jurisdiction, power, authority, so and so, in relation to recruitment and matters concerning recruitment to any civil service of the state or to any civil post under the state. Then, all service matters concerning a person not being a person referred to under clause C of this act, of this subsection, or a member or person or civilian referred to in subclause B of section 1 of section 14 appointed to any civil service of the state or any civil post under the state and pertaining to the service of such person in connection with the affairs of the state or any local or other authority under the control of the state. So, my lord,
It has the jurisdiction to consider all service matters.
matter.
There is no dispute.
yes. Then, my lord, A. First is A. Recruitment process. My lord, I have questioned the recruitment of the private respondent. But there were two recruitments. First recruitment, he was a revenue officer of
No,
a
whether you can approach, where do we find that?
But
The-
there is no bar.
no,
there is no bar.
jurisdiction is
The
to
jurisdiction is there, but who can approach? Well, that is not been mentioned here.
the person whose service conditions are being disturbed. That
Amalat-
person can approach the tribe.
But that is, kindly have,
Can
can
a
you see?
third party go?
But that embargo is not there in the act.
No, that we
But
have
that embargo is not there. But what I am on is, but kindly, but give me 2-3 minutes time, but to apprise your lordship. But my case is that my husband had mixed up with the state administration to avoid the police verification. There was no police verification.
please, Mr. Bhattacharya, satisfy us that a third person who is not in government service
True.
can approach the tribunal for determination of an issue of a person in state government service.
But that bar is not there, express bar.
Have you checked up?
But I have
You have
checked
to
up.
apply
That is,
your mind, no?
it's a
Please,
pure question of law. But I have come, there's a pure question of law.
Do you have any authority on that issue?
Then I have to
Okay,
come.
that is what I'm saying. No?
Give me 1 day time so that this weekend I can search it out. It's a pure question of law. Because the High Court has granted me the liberty to approach the State Administrative Tribunal. And armed with that order, I have gone there. There is a judicial order. The act does not debar me from approaching the tribunal. The police report is annexed that there was no police verification for the entire year.
You are not concerned with
He-
that.
You are not concerned who can approach. Admittedly, tribunal has the jurisdiction to deal with a service-related matter of a state government employee.
True.
But on the basis of whose application?
Well,
On the basis of the application of that employee or on the basis of the application of a third party?
this is the
That is
answer
the
is
question.
the answer is
Yes.
I have approached, I have knocked the door of the government time and again.
No, maybe.
When the respondents had failed, I have approached the High Court. The High Court had dismissed my petition without High Court has dismissed my petition by holding that I don't have the jurisdiction. It is the State Administrative Tribunal who has the jurisdiction. So go there.
That order stands as of
Yes.
Where
By
is-
the
where is that order?
yes. Kindly see Justice Banerjee's order once.
আমরা শুনিনি।
Kindly give me 1 minute time.
Page 30.
Page 29 starts. 17th of August 2023. Page 30. Yes, this court is of the opinion that the writ petition is not maintainable since the dispute is private in nature. Furthermore, this court finds that the private respondent number 8 is a state government employee under the Administrative Tribunal Act 1985. The writ petition is not maintainable since the petitioner is also seeking to challenge the recruitment process of a state government employee.
Yes. But that is what you have sought for. That is not a court's direction. Court has narrated what you stated. That he is seeking to challenge the recruitment procedure of a state government.
This court finds, this is observation of the court. Furthermore, this court finds that the private respondent so and so
under
yes.
the writ petition. Stop.
Then
Under the writ petition, under the admission, writ petition is not maintainable since the petitioner is seeking to challenge the recruitment procedure of a state government. Does not say that you go to the tribunal and the tribunal will decide in accordance with.
no, that express wording is not there. That express word is not there. But
That is
Court-
a supplementary argument. You
yes,
show us that being an independent person, you can go to the tribunal.
my answer is there is no bar in the act. In the act, the act does not debar me to approach the tribunal. When I approach the respondents, I failed, then I approach the
There
tribunal.
is a
One. Who can approach the court?
Well, that is not
That
expressly.
is the person aggrieved.
Yes.
Who will be stated to be a person aggrieved? Whose right, either legal right or fundamental rights, has been infringed. Now, if you are asked what right has been infringed, that if any department has given a wrong appointment to a person, what personal right is, it is not a appeal. What personal right has been infringed? What is the personal right infringed of the petitioner?
Well,
Maybe for the sake of argument, one department has erroneously undertaken, initiated a selection process and chooses a wrong person. So the third party, how he is aggrieved? Locus come from his aggrievedness. That he has aggrieved. I am
Understood,
personally
understood.
aggrieved. My land you have taken, so I shall go to the civil court.
considering the tribunal has come.
পয়েন্টটা কোথা থেকে ধরেছিলাম তুই ধরতে পেরেছিস? তুই কোথায় ধরেছিলাম ধরেছিস? কাল রাত্রে কোথায় একটু কোথায়
আমি তো বইটাই পাই।
Come with some
Yes, I
any legal authority on this issue. We have to decide the point. Give a copy to your friend.
Yes, but I have already served the by post. I have already sent the private respondent by WhatsApp, the entire scan copy. But I will give him a copy.
Give a
Okay, hard copy.
But shall I come on Monday or Tuesday?
You file an opposition to this.
What operation?
Short opposition to this, he will file a reply, we will decide.
My lord,
State will also file.
My lord, here, my lord query is whether the third party come within the ambit of person or not. My lord, I think my learned therapist what already placed before your lordship, 3Q is sufficient. So for my
2Q,
submission,
2Q.
3Q,
3Q.
3Q,
What is 3Q?
subject to my lord consideration. 3Q, service
Three,
matter.
no. It is not 2Q, it is 3Q.
3Q, it is 3Q.
No, we understand.
All matter relating to the condition of his service.
He has not challenged his own service. I have challenged
And-
the
and another-
appointment.
Let him come, let him
And
come.
another thing, my lord, what I already submitted with your lordship, he invoked the jurisdiction of
Boss.
section 15, not 19. But invoke the jurisdiction in section 19 is mandatory. It is stated in 3B.
Come with that, we will consider.
My lord, application 3B. Application means an application made under section 19. Original application should be made under section 19, not under 15.
এই পার্সন এগ্রিভটা চলে আসে
কোথায় percent?
এই যে পার্সন এগ্রিভ কথা বলা আছে না 19 3B টা তো একসঙ্গে মিলে
Read করলে ওটা চলে আসে।
রিড করলে এগ্রিভটা চলে আসে
Section 15 confer jurisdiction.
There is a judge, I don't remember just now, there is a judgment of Justice Pratap Rai, as his lordship then was. That is a Kendriya Vidyalaya matter.
Yes,
Citation I am forgetting.
but I'll search for it.
Third party can interfere or not.
No, not on the, there it was a private institution was involved. Many Supreme Court judgments were relied upon. Yeah, I'm, citation টা আমার কাছে এখানে বলছে।
But,
We shall check up, we shall check up.
But, what is the judgment of the order?
That is the Kendriya Vidyalaya employees came to the tribunal. Then it was not entertained. Matter came up to the High Court. High Court said that yes, that application would be maintainable. Some Supreme Court judgments were also considered. We shall check up. We shall check up. Now we
But here the
he's one thing is that he says that section 3B is an application and means an application under section 9.
hmm,
An aggrieved. There is no aggrieved আমি হতেই পারি যদি কেউ আমি যদি ওভারেন্টতে আমরা করি যে যেমন সিঙ্গেল বেঞ্চ শুনতে পারি
Oh,
না ডিভিশন বেঞ্চ
ট্রাইব্যুনালে কোয়ারেন্টি করার পাওয়া নেই
section 19.
সেটা অন্য আর
19 দেবো how
NT.
appreciated.
But the present writ petition has been preferred, challenging an order dated 13th of October 2023 passed by the learned tribunal in the original application, being OA number 719 of 2023. Upon hearing the learned advocates advocating for the respective parties and considering the materials on record, we are of the opinion that the matter needs to be decided upon exchange of evidence. Stop. The respondents are accordingly directed to file their affidavit in opposition within a week after the vacation. Reply thereto, if any, be filed within a week thereafter. The parties would be at liberty to mention the matter for enlistment and hearing after the period specified above towards after the expiry of the period as specified above towards exchange of evidence. Mr. Mukherjee, you also.
I'm praying apology if I have done anything wrong.
We belong to the same fraternity. It is not a question of personal like and dislike. I have a right to scold you and admonish you. Because you are younger to me, not only because of this, but you are. Don't take anything personal. We have nothing against you.
Grateful. Grateful.
Deeply grateful.
Because why sometimes I tell you, na, this is my personal experience. In my practicing error, I noticed that when you that
Obliged.
Grateful to Lord.
Great. Great.
give us a copy just.
Sure. Right, I'll Xerox it.
With page marking, my lord.
No, no, I
No,
will
sir.
sign. Okay, I cannot.
Xerox তো করা যাবে
Paginate and give it.
এই অসীম তোমার নাম।
Already item number 2, I am late
ডাকতে দাও। Yes.
in this matter. In this matter, I am led by Mr. D.N. Rai. He has not.
Yesterday also you took
Yes,
that.
my lord.
What is the matter about?
Actually, the notification was issued, the post of Rajbhasha Adhikar, which at that Rajbhasha Adhikar in the Southeastern Railway. At that time, this post was Group B. Thereafter, during pendant panel was published, they successfully appeared, and Viva was held. Panel was prepared July 2022, 2020. During this time, a notification was issued. This post has been abolished. That's why they have not abolished, and the post has been which has been upgraded as post grade A. That's why he has not get put appointment. Thereafter, he come before the tribunal. The tribunal has passed an order that this is the laches on the part of the Southeastern Railway Authority. So you can you give the appointment as post as you.
No, you promoted a person to a particular post which was subsequently abolished.
Yes, ma'am.
He has no part to play as regards such abolition.
Yes, ma'am.
So if there is no Rajbhasha Adhikari,
There is a Rajbhasha Adhikari post is there, but that post has been upgraded as A. B post has been abolished. That by a notification dated 8/10.
So prior to abolition, he was promoted.
Promotion, but he was not appointed actually. The panel was prepared.
Oh, he was not appointed.
Yes, panel was prepared. During
You are appearing in person.
Yes, my lord, I am appearing in person. I'm respondent number 2. and already I have served 1 year as Group B Rajbhasha Adhikari post
That
and
is a Group B post.
Group B post, and this post was existing in 2019 notification. My selection was completed under RBE 53 by 2019, and as he is telling about the notification of Group A came in 2023, my lord.
But were
2023.
you appointed to the post of Rajbhasha Adhikari?
Yes,
Were you appointed to the post?
yes. I was
Selected.
selected and appointed,
Appointed.
and I have completed my 1 year of
Where is your
service.
appointment letter? Where is your appointment letter?
Appointment
Where is your appointment letter?
reversal letter is here.
Where is that?
In where it is mentioned
Yes.
in reversal letter, it is already mentioned, my lord, that
Page.
page
Page of
number.
the
Okay,
reverse.
okay, my lord.
Page 20 is the notification. Which
Mm,
notification?
is speaking order, page number A38,
Remember?
Oh, typed copy, yes.
typed copy.
That is page
51B, 51AB,
compliance of joint understanding on
51AB.
This published on it is admitted that this selection was carried out. Dismiss for dismiss for
Try to speak. Page
the administrative carried out in terms of during question has issued notification. During the course of examination, panel cancel. Panel was cancelled also.
That's here he has written the
Terms
purely
of
this is
review,
the
panel required board's approval prior to cancellation, which possess. Where is this IREM para 204-10? What কি authority আছে to cancel the panel?
সেইটাই এবার ও বলছে বোর্ডের ইয়ে দরকার ছিল এই
ও
জায়গায়
নিজেই বলছে বোর্ডের অ্যাপ্রুভাল ছাড়া ক্যান্সেল হতে পারে না।
হ্যাঁ
আবার ওই ক্যান্সেল।
সিলেকশন প্রসেস নোটিফাই হয়েছিল এইখান থেকে টাইমটা বেরিয়ে গেছে 2019 সাবসিকুয়েন্ট এটাকেও রেট্রোস্পেক্টিভ দিয়ে পুরির এটাই কেস ট্রাইব্যুনাল কি proper to regard. এটাকে টাইমার ওয়াশ করে দিই এই ব্যাপার।
complete na, after more than 1 year, the process was completed with the promotion of the applicant. Where is the memo of 20th July 2020? Uh, 20th, page 62. The appointment letter.
That memo has not been annexed, my lord.
Annexed,
Annexed,
page 62.
annexed, my lord.
General staff approved by general manager for promotion, for which written test held on ATO. Total number of notified vacancies and fusion selected list. The above candidate found medically fit for empanelment. Promotion of their should be regulated subject to condition free from. This is not the appointment letter. Where is your appointment letter, sir? Where is your appointment letter?
Appointment letter. Yes, my lord.
Appointment letter has not been annexed because the notification was published. Thereafter, he applied for. Applied for and Viva was held on April 2020. Thereafter, July 2020, panel was prepared.
Panel candidates were promoted.
I joined on 24th.
Was the appointment letter now?
Appointment letter is not annexed here.
Not annexed. You must be having your appointment letter.
Reversion order is only there.
Uh-huh.
Reversion order is only here.
Reversion order is there.
Yes, yes.
Reversion order says that you were not promoted, you were selected.
No. In speaking order, it is mentioned,
Yes.
my lord, that I was found suitable.
You were selected, you were found suitable.
Yes. Result published on 31st. It is
So
admitted
what
that
you have done
selection
to
was,
that Rita?
my lord,
Rita, the other
Same.
identical case, my lord.
Identical.
Case is identical, my lord.
Common order passed by the tribunal.
though you have been found suitable and promoted to the post, your promotion has become erroneous.
Yes, madam. Page number 20, it has been notification was issued 18/11/22. 20.
20.
Yes, ma'am.
Yes.
18/11/2020. It has been brought to the notice of the board that two official of, namely Rajendra Dubey, translator, senior translator, as the senior translator, KGP, and Rita Koyam, junior translator, KGP, have been empaneled to the erstwhile B group, Group B post of Rajbhasha Adhikari. In terms of railway notification 20, July 2020, after categories of these posts as grade A in level 10 of pay matrix, wide pay commission letter dated such and such. Therefore, as the said empanel is invalid, it is desired the suitable corrective action may please be immediately taken by the Southeastern Railway. Thereafter, so-called notice was issued.
Why the empanelment is invalid?
So due to this notification has come the.
Where you have stated that upgradation?
My lord, in 51.
In terms of the railway notification 2020 after categories of these posts as grade A in level. Thereafter, in so-called notice also same has been stated, my lord. Thereafter, next page 21 in so-called notice.
For these official revised, paragraph number 4, these official revised letter from Railway Board bearing number such and such, Rajbhasha dated 18/11/20, stating inter alia that impanel to the erstwhile Group B post of the Rajbhasha Adhikari in favor of the Rajendra Dubey, translator, senior translator, and Srimati Rita Koyam, junior translator, invalid consequence upon categories of the Group A, Group A as level 10 matrix, White Paste Commission such and such.
My lord, in so cause notice, second para says, Bhaiva Vosi was held on 9/7/2020 for the two candidates
Then where is the
and
after
declared,
the show cause
declared
what
as
happened?
successful candidate,
After this, so speaking order was passed.
They went
accordingly
no,
promoted.
they went to the tribunal earlier. A tribunal passed an
Tribunal-
order of 11th June.
Yes.
Where is that order?
This is order dated page number 20, sorry, page number 27.
27.
Yes, ma'am. Therefore, without
Acha, you please come to the speaking order 51A. Kindly come to the penultimate paragraph 51B. The reason for delay in finalization of Group B selection is purely administrative. There was representation which was to be disposed of before publication of results, and then there was a change of selection committee that took substantial time during the lockdown period. Apart from the above, it is for your necessary information that in terms of para 204-10 of IREM, Group B panel required board's approval prior to cancellation.
Yes,
You bring this IREM volume 1 para 204.
yes,
If
ma'am.
the approval of the board was required, then how can your officer cancel it?
Yes, ma'am.
He himself says that it can be cancelled only with the approval of the board. Then he says, which procedure causes lapse of substantial time to take administrative decision towards cancellation of the panel. Administrative decision towards cancellation of the panel dated dato is hereby cancelled. How he can cancel?
Yes, yes.
Huh?
That notification has to be required, my lord, brought into the notice, your lordship.
Your lordship, there was no complaint and proper selection was done, and I have done completed my 1 year of service.
You are not understanding. Let him argue.
Yes, ma'am.
You bring your appointment letter. If you have any appointment letter, bring it to us.
Before this, he was a senior translator.
You got the salary under in the promoted post, Group B
Yes,
scale.
yes, for 1 year I have got. 1 year. Right from 24th July.
So, where
24th July 2022 to July 2021. More than 1 year.
bring your pay slip.
But in the way they have not.
Yes,
created
my
that.
lord.
You must be having your pay slips.
Yes, my lord. I can download and show you, my lord.
We are fixing it. He will bring this regulation. We will hear it out. Follow.
Yes, my lord.
Bring your appointment letter if you have,
Yes, my
and
lord.
bring your pay slips that you got the Group B scale of pay.
Yes, my lord.
Bring these two things.
Printed copy.
If you have with you, bring a Xerox copy of the same.
Yes, yes.
Not now, not now.
Okay, my lord.
Where is this para 204-1 IREM volume 1?
That has not been annexed, only stated is that I have, that I have to bring, call for.
পয়েন্ট হচ্ছে তুমি যদি প্রমোটেড না পোস্টটাই যদি না দিয়ে থাকো, এখানে ট্রাইব্যুনাল প্রসিড করছে এই বেসিসে যে হি ওয়াজ প্রমোটেড। The process was with the promotion of.
What you have done with the existing group B category of staff, you have upgraded.
Upgraded a group,
Group
group
A.
A. because group B,
So you will not upgrade this candidate.
that panel has not been affected.
Even today, no Rajbhasa Adhikari has been upgraded. All are in Group B service, my lord, and nobody is reverted except us.
Now you are getting Group B scale or Group D scale? Now?
Now I am getting Group C, my lord.
Uh,
After reversion in 2021. Thereafter, I moved to Central
you are
Administrative
getting Group
Tribunal.
C,
Group C, my lord.
that is higher than Group B.
Lower than Group
Oh,
B.
Group C.
Group C. After 1 year of my service, I was reverted deliberately by the railway administration.
Since when you are receiving the Group C?
After
After the cancellation.
after reversion, August 2021, I'm getting prior Group C post salary.
Hmm.
And no other officers have been reverted, my lord. This is a case of biased officers. Officers are biased, so they did so, and still today they are not sanctioning my leave and deducting my salary. Whenever I need leave, I apply. They do not. They do not sanction it. And thereafter, I requested higher official to transfer me. And I just last week I transferred to railway workshop from Kharagpur division, and their officers are good. They are sanctioning leave now.
And you are getting Group C scale.
Group C salary, my lord.
On 30th July 20.
And other officers were not reverted, my lord. If before 2020, Rita Kaim is also Group C because the same panel.
Also reverted.
She also reverted because in
The other person,
our name are in same panel.
any person is working in Rajbongshi Adhikari post. Today nobody is working. Others are working.
Asha Misra of my batch, she promoted in 2018 in Group B. Still she is in Group B.
Rajbongshi Adhikari post.
Rajbhasa Adhikari post. Still in Group B she is. She is still in Group B, not in Group A.
He has not been upgraded.
Not upgraded because upgradation implemented from 2023 January. I have gazette notification, my lord. 4 copies I have. Look here, sir.
You bring those documents. When can you come?
Okay, you.
Group A implemented from 23 this year, not in 22, 20 and 21.
Will you be able to file supplementary affidavit?
This is notification. He is telling that Group A notification.
Actually, what's not within the record, we cannot see. You can file a supplementary affidavit. You annex your appointment letter, pay slip, showing that you are drawing Group B scale. And thereafter, now present pay slip you can also annex, and the notification upon which you want to rely.
This one.
ঠিক আছে, ও বুঝতে পারবে।
Group A notification.
আচ্ছা, তো you come on next.
Rajbhasa Adhikari Group A.
Okay, we shall take on record. We shall take all these documents on record.
Next on 18 May.
You assist him how to file
Yes,
supplementary.
yes, I will.
18 তারিখে। On 18th it will be there. Come with those documents.
On
18.
December.
All right.
Yes, my lord.
Next. এটা অর্ডার করে দাও।
But I appear for the state respondents.
In course on 18th we have kept.
Yes, ma'am.
You bring those circulars,
Yes,
all those
that
provisions
204 and with provision.
in course of hearing. In in course of hearing. ওপরে দিয়ে দেবে ওর নাম appearing in person. In course of hearing, Mr. Sachin, learned advocate appearing for the petitioners. Please put an accommodation to avail necessary instruction. Stop. Please the matter for further consideration in the daily supplementary list of this court on 18th of December. We have said that you are adjournment you are taking for bringing those circulars.
Yes,
for instruction on. Yes. Next. তুমি কোনো মামলা শোনা যাবে আজকে শুনে তোমার সাথে কালকে
Well, I am for the petition. Here is the affidavit of service. Well, this is a matter where the learned tribunal has dismissed my application, which was filed for correction of record of right. Now, my lord, the fact of the case is this: father of the petitioners, my lord,
just let us go through the order. Yes.
my lord, the fact of the case is this, my lord, the father of the petitioners got a settlement of the 28 decimals of land in the year 1939. The Amulnama was unregistered. Now, subsequently, father settlement documents.
Settlement nice.
So, after getting it,
Father got a settlement.
in the year 1939
From
from private parties, their names are,
Jomindar,
yes, Diden
Diden Jomindar,
Mar-
by executing an unregistered Amol.
Amul.
Yes.
Subsequently, out of 28 decimals, my lord, a pond was dug and race course and a dwelling house was constructed. So after death of father, my lord, the petitioners got the possession of the property and they are still in possession. Now they applied for long-term settlement. Your lordship kindly come to page 19. That is
Why
the
why long-term
long-term?
settlement? Your
Correction of-
your predecessor was on the basis of the Amolnama. He
Amalnama. Settlement. So initially they applied, that is at page 14, my lord,
Oh,
the in
so in CS RR, whose name was recorded?
Jamindar CS,
Thereafter in RS,
RS only Khal and ব্যবহারকারী, that is সর্বসাধারণ. That I have annexed.
that means it was vested to the state.
They are claiming,
Yes.
but my case,
And
Deeply
the
obliged.
Jomindar did not retain the land.
Deeply obliged, my lord. Exactly, that is what is happening. It is invested.
It has been vested to the land.
my lord,
government.
that may be the,
Now you made an application before the concerned authority that you settle the land.
because, my lord, I am residing there
My lord,
after
absolutely.
making construction. Construction is almost 90 years, 85, 90 years, my lord. Now, your
now
lordship,
you applied for settlement when?
in the year 2014, that is at,
You applied for settlement in 2014.
my lord.
My lord, page 16, if your lordship kindly.
Acha.
That was the application. On the basis of that, my lord, an inquiry was held and the DLRO, ADM DLRO on, my lord, that is at page 19. On, my lord, 25th of February 2015, he placed a detailed report to the Joint Secretary, LR Department. Now, third paragraph, the report of BL and LRO speaks that the plot number 125 with total area 0.92 acres classified as Khal is vested to the state and the petitioner has been possessing 0.28 acres land since 1939 by Amolnama deed in between such and such, the forefather of petitioner till date without having any easement right in the said property, a portion of the water body. But in reality, my lord, my respectful submission is this: there is no khal, no water body, nothing. Enters nature of the plot.
Point is not that. Tribunal said that your case is that you have applied for settlement. And
No,
on just a
subsequently-
moment. And on the other hand, you have also filed an application for correction of records.
Since
Wait,
my
wait,
lord,
wait. Let us understand. So tribunal says that these are mutually contradictory and dismissed your petition. Question of incorporation of your name in the records would occasion only when long-term settlement is approved in your favor by the government. Your prayer is to the BLRO correct the record of right. How can he do that? Because it is a vested land for which you also, knowing it is a vested land, you applied for long-term settlement.
now my lord, your lordship kindly since the long position of more near about 100 years, my lord.
Go and file a suit. Seek protection from the civil court that protect my possession. So the civil court will give you that.
But my lord, the other side is this, my lord, the practical record of right is prepared on the basis of the practical situation. Now there is no khal. Entire plot of 125 is possessed by
When was your application for correction of record of right?
that
Maybe
is
there is a wrong.
Well,
record.
two applications has been made. One by the respondent number one, petitioner number one, the brother. That is at on 2014. And thereafter, after the end,
2014 was for settlement.
my lord, yes, my lord, that is at page 19, the order has been passed. That has been shown.
No
Now,
order
the
passed.
other,
No order passed, referred to assistant secretary to take a decision.
my lord, ultimately by, if your lordship kindly
Long-term
takes up page 20, my lord,
Rejected.
yes, that representation was rejected by this report.
no, not
The land is
rejected,
Khalwai classification.
not rejected, page 20.
And I'll show from, because register book 8, it is appearing and it was in 59 itself, it was vested to the state. And thereafter, he is applying for the first time in 2014 by way of a private settlement which is unregistered.
Now, when did he apply for correction?
That
my
is
lord,
at page 21.
The other brother, that is respondent number 2, on the same issue, he is saying, my lord, fresh representation, page 21.
That is what is the date of this? 10th of April 2017.
17. 14, 17, two applications. And 14, he is saying, I am in possession. Thereafter, here he is saying something different. The stand is changed. They are,
The two brothers are not here. They are brothers here.
Yes.
yes, both has made an application, but they have not challenged the first one.
It was vested before CS operation.
My lord, kindly see, I may produce the document.
1959.
59. When the act came into, it automatically vested unless retained.
Operation, it was vested.
My lord, the long
Actually, Jamindar executed Amolnama in your favor, but he has not retained the land. As is
Like exactly that is what has happened.
but my lord, the real
and hence the land has been shifted to the government.
my lord, kindly
Shifted to the government. Now, unless and until a patta is given to you, or somehow lease or anything is given by the government, nothing will.
my lord, your lordship kindly appreciate the present situation.
So the prayer for correction of record of rights is wrong.
My lord, from 9
Now, maybe there is a wrong recording regarding classification of land. You are saying that it is not a khal, maybe classification of, but regarding ownership,
either long-term possession or my lord, because they are residing there.
classification.
My lord, may I hand over two documents, my lord?
ক্লাসিফিকেশনটা খাল বলে আমরা এটা কনসিডার করি এই বলে লং টার্ম সেটেলমেন্ট রিজেক্টেড হয়েছে
সেটা long term
লং টার্ম সেটেলমেন্ট counting opposition the land
My lord, kindly consider their long
But that-
possession and they are residing there since
Okay, you
1939, my
approach
lord.
the
My
authority.
lord, if they are ousted,
My
where
lord,
they
if your
will
lord,
go?
If they want to grant patta in your favor
That will
or
go.
settle the land on long-term basis, that court shall have no objection. You approach them, but
My lord,
the
kindly,
two documents that has
record-
been handed over, including the
record
judge.
cannot be asked to be correct.
My lord, the very first page, my lord, this is of register 8. My lord, at the top. My lord, the column that is written, the possession taken in 58-59 on 14th September 59.
file a short affidavit enclosing that
Well, this has been report that has been supplied to.
Mr. Ganguly, suppose you have not considered his prayer for settlement since the classification of the land is Khal. That your final order passed by, kindly come, page 20. In reference to this letter, this is to inform you that his prayer for long-term lease cannot be considered for the reason the land is Khal by classification, which cannot be settled with individual to keep its use for common easement purpose.
Well, that's
But-
why it is.
But the issue is that the entirety of the plot is not a Khal. Maybe a portion is a Khal.
My lord, kindly see that document itself. That's why I have handed over.
Plot is Khal.
My lord, yes, my lord, kindly see, my lord.
My dwelling house is there. How can it be, my lord?
It is the recorded
Other
portion, my lord.
parties are reciting around.
123, the Dagnam.
Mr. Ganguly, let us understand. If the classification, it appears prima facie from page 20, you have said that this cannot be settled in your favor. Why? Because the classification is Khal. Now, I can always challenge the classification by making a representation to the BLRO.
Well, that has not been done.
No, no,
My lord, I'm sorry, my lord. I
So-
beg apology, my lord.
your tribunal has rightly rejected on the ground that once you have made a prayer for correction of record, second you are making a prayer for settlement, admitting that it is a vested land. When it is a vested land, Khotian one, your name cannot be incorporated.
My lord.
That we know. But the thing is, he has an independent right to challenge the cancellation marking in the records.
My lord, perhaps that's why he has also
The second brother made the representation.
represented, and perhaps in the application itself before the tribunal, my lord,
Uh,
if your lordship kindly see the
Uh.
second prayer, he has made a prayer for consideration of the same,
uh,
the second application. My lord, let that be done. Let it be considered. Let them go.
yes.
That
yes.
there we don't have any objection.
One observation.
I must attend it. I cannot.
Lordship's list, my lord, they will be ousted. Since they are poor people, they are not rich people, my lord.
Ade, you have dug your own grave, sir.
They are village people, my lord. They
My lord, page 27 of the application, they have,
My lord,
made they have
kindly
asked for the
protect-
consideration. Let it be considered.
Uh.
There we cannot come in the way.
My lord, it was
My lord, page
considered that-
27.
my lord,
That is a part of the application filed
Uh,
before the tribunal.
Consideration, once we say considered that, the fact that it is a vested land stand approved.
But my lord, if your lordship,
Then the next round of litigation, you will say the infraction, it is a not entertainable at all because it is a vested land.
but my lord, ultimately that will come. My lord.
Actually, in Land Reforms Act, there is a provision 14.
yes.
Mm.
Except this, in Estate Acquisition Act, there is no provision.
We cannot reopen. Or
That
is the whole
vested
issue.
land is given to
once it
another
is vested,
person.
it is vested at that point of time by the statute.
You take instruction that if your purpose, we will say that he has made an application for alteration of classification of the land. If you do that, the authorities will consider, finish.
My lord, that order may be passed today also, or if your lordship.
Considered in accordance with law, that will be considered, otherwise কি আর করবে এছাড়া?
তাই না? আমার এভাবে এটা 1 নম্বর খতিয়ানে আছে, আমার কালেক্টরের ল্যান্ড।
And my lord, one indication may be given as
But the
from your lordship, my lord.
যদি বলা হয় consider
perhaps the difficulty what
করবেন। এইটাকে আমরা টাচ করছি না, কিন্তু
Mr. Ganguly will take,
we'll take instruction to the effect. I got your lordship. My lord. But perhaps what has created the trouble is page 16.
absolutely right.
One brother is saying, I am a Dokholdar,
Uh,
and
one goes to High Court, one goes to civil.
my lord, that is
Cannot prevail.
that is true. And none of them has disclosed that they are brothers. They are of the emanates from the same property, same.
of the land. And if such application is made, they
সে তো করেছে। Settlement এর-
contradictory বলে করেছে।
না না ও তো ওইটা রিজেক্ট করে দিয়েছে। পেজ 20 টা দেখো না। ওর প্রেয়ারটা ফর লং সেটেলমেন্ট হ্যাজ বিন রিজেক্টেড। ইট ক্যানট বি ডান। এই যে আর পেজ 19 এ বলে দিয়েছে ক্লাসিফাইড অ্যাজ খাল ইজ ভেস্টেড টু ল্যান্ড।
It is the report. Page 19. It is the report of the BLL.
Next page.
লোক পাঠিয়েছে না পিটিশনার পাঠিয়েছে এটা টাইম ক্লিয়ার
Mr. Ganguly in page 19, third paragraph, the report of BLRO speaks the plot 125 of such and such classified as Khal, and the petitioner has been possessing such and such acres since 1939 by. যদি খালের প্লটের তাহলে রিমেনিং পোর্শনটা কি খাল কি সেটেলমেন্ট তো করতে পারবে
না ওই জন্যই করে
রিমেনিং পোর্শনটা তো চিন্তা করতে পারে
হ্যাঁ বাস্তু হলে সেটা চিন্তা করতে
না বাস্তু করবে কি তো ক্লাসিফিকেশন ভুল হয়ে রয়েছে
ভুল হয়
আগে ক্লাসিফিকেশনটা রেকটিফাই করো Mr. Ganguly, please take an instruction that from the BLRO report it says that yes, the plot is Khal, but part of it is being owned by him. So far as that portion is concerned, whether you can consider his prayer for long-term settlement, that will serve his
So
purpose.
kindly then record this one. We will take a specific instruction to this effect on the basis of the court's query. My lord will answer to this specifically.
ইনস্ট্রাকশন নিয়ে আসুন বিশাল বাস্তব একটা বাঁচবে না
Because only issue that will come up is that once it is vested as per the statute,
Mr. Ganguly, it is vested, entire plot is vested, which has a khal and a portion is occupied by him.
as a Dokholdar, as he has said at that point of time.
As Dakhaldar. Now your authorities are proceeding on the line that the entire plot is khal. So we will not do anything. It cannot be settled. But your BLRO inquiry says that part is being occupied by him.
My lord,
To that effect, you take an
we'll take a
instruction.
specific instruction to that. We will reply to this.
The present petition has been preferred, challenging an order dated 17th November 2022, passed by the learned tribunal in the original application being OA 1407 of 2021 of bracket A LRTT, সবকটা capital. এর নামটা কি হইলো? Records reveal hard learned advocate appearing for the petitioner. Records reveal কি বললেন? No, hard the learned advocates appearing for the respective parties. Next, from the memo dated 25th February, from the memo dated 25th February 2015, it appears that the plot number 125 consists of 0.92 acres classified as in the কি লিখলে? In the memo dated না এরম লেখো next para, in the memo dated 25th February 2015, it has inter alia been it has been stated inter alia that বলে কোট আনকোটে এই পোর্শনটা দিয়ে page 9. Subsequent thereto, the petitioner's prayer for long-term subsequent thereto by a memo dated 3rd March 2016, the respondent number 3 stated inter alia that না respondent number 3 কি ADM কত তাকেও পার্টি করে you have not made the additional district magistrate a party
Here and now I am.
কি লিখলেন
ও ডিস্ট্রিক্ট লাইন হ্যাঁ পড়েছে আমরা ইয়ে
DLRO না
টু
subsequent thereto by a
Respondent
memo
number two.
dated by
Respondent number 2.
subsequent thereto, the respondent number 2 by a memo dated 3rd March 2016 stated that the petitioner's prayer for long-term lease cannot be considered for the reason that the land is quote unquote a khal by classification.
যে কেন এটা কন্ট্রাডিক্টরি নয়, ও খাল বলে ওকে সেটেলমেন্ট দিচ্ছে না, আর এনকোয়ারি রিপোর্ট বিআর বলছে যে এত সুতরাং এটা যদি কারেকশন করে বাটাদাগ করে যদি কনসিডার করে তাহলে সেটা একটা কথা নয়, ওর রেমিডিটা ওইখানেই আছে, এটাকে বাটাদাগ করতে হবে, করে বাড়তি করে ওকে সেটেল করতে হবে।
So we can pass that order now.
Or shall I come up with an instruction for within a very short time, one-page instruction so that I may also be.
No, then Mr. Ganguly, you take this instruction and come with a written instruction
Yes, yes.
that they can consider. If they can consider, we will ask him to make a representation to that effect, which you will consider.
But if appropriate applications are filed, it has to be considered. We cannot sit.
Acha, you come with this instruction.
No, tribunal says it is contradictory. Why he made two sorts of application? BLR concern stated that the entire land is khal, so khal cannot be settled to any person. But your video or any inquiry found that 28 decimal is a Bastu land. He is enjoying the same. And the rest portion is khal.
I got.
So you should have made it butter plot.
Butter plot. Yes, I got it.
Butter plot
And
settled.
butter plot and 1% could have been settled if you want to settle. And hence two pair came. He said, the 1% I am residing, making a construction of my house, so it cannot be khal. You correct. And next pair settle.
আমরা however immediate fix an application to consideration এটা ও সেটা চাইছে না ওর ইনস্ট্রাকশন নিয়ে আসতে চাইছে
One short written instruction will.
No, you are asking us to state what instruction you will
Yes, yes. A small only with therefore we will come with a specific instruction.
No, we are you don't want us to record this.
Yes, yes. Recording of this, that a specific instruction has been passed by the Honorable Court, so I may ask them for that instruction. It will be considered in accordance with law, whatever will be. Well, at a short, if it is the next week, well, it will come in with a short.
Next week,
A written instruction দিয়ে পাঠিয়ে
Mr. Ganguly, হ্যাঁ হ্যাঁ পড়ো কি লিখেছো কেটে দাও আগের মেমো যেটা দিয়েছো হার্ড দি লার্নেড অ্যাডভোকেটস এবং কনসিডার দি মেটেরিয়ালস অন পেপার তারপর লেখো তারপর ওইটা কি বললে ফ্রম দি ওই যে মেমোটা ইস্যু করেছে বলেছো হ্যাঁ লেখো ওটা দি রেসপন্ডেন্ট নাম্বার 3 by a memo dated 3rd March 2016 observed inter alia that the petitioner's prayer for long-term lease in the concerned plot cannot be considered for the reason that the land is khal by classification. Stop. However, from the memo dated 25th February 2015, issued by the self-same respondent, issued by, it appears that there is already a report of the BLN of the respondent number 3 to the effect that the entire plot is of 0.92 acres classified as khal, and the petitioner is enjoying, and the petitioner is possessing 0.28 of the acres of land since the year 1939. In view thereof, Mr. Ganguly, learned advocate appearing for the state, is directed to avail necessary instruction as to whether the petitioner's prayer for long-term settlement of land pertaining to 0.28 acres in plot number 125
ক্লেম করছে যে ঘর বাড়ি করে বাস করছে
orderই হয়ে যাচ্ছে, আর কি instruction নিতে বলবো?
এইটাই
We are giving findings of that.
ফাইন্ডিং
Well, my lord, then let that be considered in accordance with law. My lord, let it be disposed of in accordance with law. Let them go. Whatever there is in the report, there is in the report. If you want to contradict something otherwise, you will have to come up with a specific finding then, while considering the representation.
But once your lordship dispose in that fashion, my lord, then they are very extremely poor people, my lord. They will have to go to tribunal, 2 years, 3 years, one application they require for
For
disposal.
that you cannot
No, my lord, one.
আচ্ছা
Sir.
শুধু এরকম লিখে দাও, heard Mr. such and such learned advocate appearing for the petitioner. Mr. Ganguly, learned advocate appearing for the state, is directed to avail instruction as to whether the portion of land, being occupied by the petitioner in plot number 125 can be considered for grant of long-term settlement in favor of the, grant of long-term settlement. এইটুই, ওটা কে দিয়েছে আগে?
যেখানে ও ঘর বাড়ি করে বাস করছে
ওটা বলিনি,
ক্লাসিফিকেশনটা ভার্চুয়ালি চেঞ্জ হবে এটা
সেটা ওই ইনস্ট্রাকশন আছে, তখন ওই অর্ডারটা আমরা করে দেবো।
ঠিক।
কি লিখলে তাহলে ওই প্রথম
এগুলো কেটে দিন।
লিখিত ওখান থেকে অনলাইনে আনি নেবে কি আছে, আর কি দেবো?
advocate appearing for the petitioner, তারপরে বলবে মিস্টার গাঙ্গুলি learned still is directed to
Returnable on,
matter for further consider.
returnable on,
When do you want it? Tell us. When can you take the instruction
but when next week itself.
for further consideration in the daily supplementary list of this court on 19th December? Yes.
আজকে
Mr. Ganguly, if that can be considered, we will dispose of the matter.
Yes, we'll that's why I've asked at shorter time. We'll come with specific that instruction, that whether what is the exact scenario, and
Yes.
because only one thing, they are now supplying with a document that shows that the entirety is under vesting.
Forget
Yes,
it.
yes. That's why I
Because classification can always be, if that is now classification can be made, BLRO is the authority. So to cut short the method, as he is in possession, otherwise he has to run to the civil court to obtain a declaration that I am.
will do.
And let the BLRO give a written, not the BLRO, the ADMLR, DLRO will give you a written instruction.
Yes, written instruction will come up with.
Next. বারোটায় কি fixed আছে?
मैं समझ गया बेटर होगा तो
যে একটা মোশন নিয়ে তারপরটা মোশন আছে এখানে। নেক্সট দেখুন তারপরে 12 নুনটা ডেকে দিন। আইটেম নাম্বার 4, yes,
I appear for the,
you are for the petitioner.
I'm for the petition.
Yes. Yes, Mr. Koli.
Blood, certain lands were purchased by the appellant company from blood various blood villages blood in Uttar Dinajpur. This happened at a point of time when this was not through acquisition, direct purchase. Now,
You have
blood,
been asked to consider only.
no, blood, there is a little difficulty, I tell you, Lordship,
What?
why. Blood, there was a first round of litigation. Blood, your Lordships may kindly have a look at that order. On 1st of March 2016, an order was pronounced by this Honorable Court. Your Lordships may kindly come to page 48. Blood, please come to page 51. Blood, after recording the whole facts, this was what was directed.
Permitting the petitioner to furnish
His biodata indicating his age, educational qualification and like to other senior manager, HR and A, employee service, the distribution company within a week from date. Such official, along with the director HR of the distribution company, will be obliged to inform both the petitioner and the petitioner's son of the next recruitment conducted by the distribution company, whereat the petitioner's son may be eligible to apply. The candidature of the petitioner's son in the relevant recruitment process will be considered by giving him weightage as a reserve category candidate with a maximum concession permissible under the rules, irrespective of whether the candidate is eligible for such concession. If after all, the petitioner's son is unable to qualify for appointment, nothing further need be done. Now, my lord, this is the order based on which a second writ petition is filed. And my lord, in the writ petition, if your lordships, my lord, now kindly see what was the allegation. My lord, his allegation was that recruitment drives have been made to recruit, my lord, in the post of executives without, my lord, informing him. If your lordships, my lord, kindly see the writ petition, paragraph 13, page 29.
So the earlier writ petition, what was the post inward?
No post. He had not disclosed his qualification. Subsequently, he gave his biodata. Now, my lord, according to his biodata, he was not qualified to be called for these vacancies for which recruitment drive was taken. That a report has been filed. I'll show your lordships the report. Where there is a mismatch so far as his qualification is concerned.
You
And
communicate to him.
I-
By a speaking order, you communicate.
Lord,
That
this
you are
this was
ineligible.
this was pointed out, Lord, by a report filed before the learned judge. Lord,
But the learned judge has considered that issue.
no,
Eligibility
no,
criteria.
it has not gone into at all. This
It is open to you, Mr. Because court did not say that irrespective of qualification, you have to
Lord,
consider.
kindly see, this is what she says.
Yes.
If your lordships clarifies that, Lord, I have no problem. Kindly come to page 4 of the impugned order.
Yes.
Kindly see from the bottom of that page. In such view of the matter, the respondent number 3 director is directed to consider the prayer for recruitment of the petition number 2 pursuant to the previous order of the Honorable Coordinate Bench dated March 1, 2016, within 6 weeks from date upon giving a personal hearing
to the petitioner. Such recent order shall be communicated within 2 weeks of passing thereof. If the petitioner is otherwise found entitled like a reserve category candidate, he should be entitled immediately considered for appointment in a suitable post within 2 months from date. Now, my lord, this
If the petitioner is otherwise found entitled.
correct. Now, my lord, the eligibility and other things were all dealt with in the earlier order by Justice Banerjee in his lordship's order of 1st of March 2016. And my lord, it was categorically said that with his biodata matching to the eligibility criteria, only then, my lord, he would be called. Now, my lord, this
Where is that?
kindly, my lord, come to page 51. Kindly, my lord, come down to the fifth line. Such official, has your lordship, lord, kindly come to page 51, last paragraph.
Yes.
Kindly, my lord, come down to the fifth line. Such official, along with Director HR of the distribution company, will be obliged to inform both the petitioner and the petitioner's son of the next recruitment conducted by the distribution company, whereat the petitioner's son may be eligible to apply. The candidature of the petitioner's son in the relevant recruitment process will be considered by giving him weightage as reserve category, etc. Relaxation, Lord, I am not on relaxation.
Then Mr.
Only
Forward,
question is, Lord, whether he was eligible for this post.
you pass the order that you are not eligible. Court said that if you conduct a next recruitment process where the petitioner's son may be eligible, so
Correct.
you say he is not eligible.
Your lordships may clarify that, Lord,
Kindly
because
clarify.
the learned trial judge has not gone into this aspect. I tell your lordship, Lord, if your lordships kindly, I have just annexed the recruitment rules only because of this. Your lordships may kindly, Lord, have a look at the recruitment rules, which starts at page 85, at page 94.
No, one thing Mr. Court, we do not. Does the first order say that when he goes to participate, give him appointment?
No, no, no. He has to, Lord, participate in the entire recruitment process.
If
No
they say-
exception.
Right. So what is maybe you are thinking that as the earlier order was that there was an obligation on your part to inform him that now I am doing this recruitment, you come here.
Correct.
Maybe he would be taking a ground that you have not called me.
Yes, that is the ground taken in the writ petition.
So this order in totality does not mean that a person who is not having the qualification for the post advertised, he will not be
This is the short point, Lord. This is the report.
that
that
Mr.
was-
Court, you pass that order that he is
No,
not.
I am only, Lord, Lord, afraid of facing a contempt. So that is the reason, Lord, I have come up before the appellate court. Lord, I just don't want to, Lord, face proceedings for contempt, because my recruitment rules clearly says that for the post of executive,
Where is question of contempt, Mr. Court? Suppose today you pass an order, that will be subject matter of a fresh writ petition. Court will say, Parihar
Lord,
is there, Parihar's guidance is followed.
I felt that there was a modification of the order of the earlier order passed by the court, Lord, on 1st of March 2016. Because, Lord, this consideration part came, Lord, I can understand the court coming to a finding that I did not call him. He qualified, but I did not call him.
Yes, we did.
That is not the case. That is not the case, Lord, found by the learned trial judge. Your lordship will look in vain for a finding to that effect.
So now you can put that in your reasoned order that you are not qualified. Why should I call you? Question of concession does not arise.
Lord, I would not add words to your lordship, Lord, whatever your lordship suggests. But Lord, there is a report that I filed. And in the report, this was categorically pointed out before the learned trial judge that he was not eligible, therefore he was not called. If your lordship, Lord, kindly look at the page 71 once. This is part of the report, page 71. I just, Lord, rest my case on this. 71.
ওখানে তুলেছিল এজ বার আপনি 112তে আসলে এটা কেন ওকে দেয়নি qualification of the qualification for age bar is concerned. ওখানে নাই who appeared on behalf of the DCA. says the petitioner number 2 has crossed the age bar of.
No, that age bar, I'm not raising that point. Age bar, I'm not raising that point. I would abide by the relaxation blood, what the order directed. I'm not raising that point.
That argument was not
I
advanced.
guess Lalnet court was given under the impression that due to age bar, he is not being.
But kindly look at blood, the report at page 71. Kindly look at my report, which I filed before the court at page 71.
Is it a part of the evidence?
Yes, it was a report filed in the form of an affidavit.
Which portion you have?
Page
71.
Page 71, page 5.
Yes.
Internal page 5. Your Lordship sees that as regards the allegation of non-compliance with the order dated such and such, is a second writ petition seeking implementation of the order. I say, the pursuant to the order, son petitioner was asked to apply before the senior manager. Then Habib Ahmed submitted his biodata along with the relevant documents before senior manager on 3rd March 2016. From the submitted document, it is observed that son of the petitioner got 47.3% in his higher secondary examination under West Bengal Council of Higher Secondary Education and his graduation from University of North Bengal. As per recruitment rule policy 2010, for the post of office executive, previous assistant, graduation in any discipline with 50% marks in aggregate from a recognized university or graduation in any discipline minimum 50% mark, HS level along with stipulated computer qualification are required. Hence, Habib Ahmed is not eligible for class 3 non-technical post in spite of being a graduate candidate. Hence, candidates with this qualification can only be considered for the post, these posts. And then, Lord, it is said that in these posts, there has been no recruitment. Page 73, your Lordships will find.
Office executive 50% marks in aggregate from recognized university.
Graduation or
No.
Graduation with 50% marks plus a computer training certificate.
Now, this person is not a graduate.
No, he is graduate, but he has got 47.3%. 43.75%.
Of being a graduate. He was a graduate.
He was a graduate, but he did not secure 50% marks. Your Lordships may turn the page 72. My Lord will find this is his percentage. And then, Lord, he doesn't have a qualification insofar as the computer training is concerned.
Now that selection process is over.
Over. That selection process is over. There is no vacancy now. And Lord, in the post that he qualifies, there has been no recruitment. If in those two posts, if there is a recruitment in future, that is the report says that he will be informed. We are trying to give a reasons as to why he was not called.
the selection process
Yes,
is
Mr. Ward.
undertaken.
Mala particular post I am not claiming. My land, which was in terms of your lordships, kindly have a look to the order passed by Justice Banerjee, which was.
Mr. Badi, what do you say that?
No, I am particular post I am not claiming. I am grateful to my learned friend, the age relaxation, they are not disputing.
Yes.
The point was taken before the learned single judge, only criteria, the age relaxation. If your lordships want, because of the fact there are several posts, technical, non-technical, I am a poor man, my land was taken in the concessional rate, then my court considered the same, and they have tried the level based. Your lordships kindly have a look to this. There, page 48. Page 48, your lordships kindly have a look. Page 48, the page 50. It is evident from the document November 29, 1995 that a few farmers or a village were convinced by the revenue and other officials to surrender their lands at a concessional rate for setting up a project in a public interest. It is evident that the petitioner and others like him facilitated the project in agreeing to sell their lands at a concessional rate without requiring acquisition proceedings to be initiated, which the concerned persons could have registered and dragged on for the years together. Considerable benefit was obtained by the distribution company on account of the gesture of the petitioner, others as evident from the relevant document. The distribution company which took over the electricity board distributes electrics and is a public utility primarily discharging a public duty in the larger group. When a such body purchases a land at a concessional rate from a group of persons against a promise
of considering one of the members of the family for future employment, at least the consideration must be evident. All the landowners who are parties to the document had agreed that the family of the petitioner, being a poorest of them, all should be considered for an employment. In such special circumstances, the respondent authorities ought to have seen the human side of the issue and facilitated the participation of the petitioner's son in any recruitment process, subject to eligibility or other criteria of the government of such process.
No, Mr.
Any
Bari,
show. This order, I tell your lordships, this order was not complied with. There are several contempt applications. It was tested before your lordships, and your lordships passed an order. Your lordships kindly have a look to the page 64. They didn't comply the order. Point was taken, appeal is pending before this court. Then, my lord, it was taken up for consideration by your lordships. Page 64. As we have invited the present appeal has been preferred, challenging the order dated 1st March 2016, passed in a writ petition being WP number such and such.
Two reports were filed detailing alleged steps on the basis of the order impugned this. Has been
Now, my lord, the Mr.
This page 64 is not in this matter.
Yes, yes. The order of the Justice Sanjeev Banerjee's order was tested before your lordships. Initial order dated 1st March 2016.
They challenged that order.
That order, and they did not comply for a long time. A contempt application was filed and it was dismissed for default. Anyhow, my lord, they kept the appeal pending for it. And my lord, kindly see the reasoning at that point of time, what they have said. Mr. Naik argues that the impugned order has been passed by the learned single judge, being obvious to the fact that no undertaking or declaration was given towards grant of appointment to any family members of the landowners in the distribution company. Mr. Bari, learned advocate appearing for the writ petitioners, respondent submits that as necessary steps are not taken by the authorities to comply with the order impugned in the present appeal, a fresh writ petition was preferred, being WP number such and such, praying for issuance of the necessary direction upon the respondent appellant herein to provide employment to the writ petitioner too in terms of the order impugned in the present appeal. Though the said writ petition was dismissed for default, a restoration application has already been filed with the copy to Mr. Naik and same is still pending. He submits that the said writ petition, 2 reports were filed by the appellant herein detailing the steps allegedly taken by the authorities on the basis of the order impugned in the present appeal. The said reports are dated 17 March and 7 November. Such fact has not been disputed by Mr. Naik. Since the appellant herein have already taken steps and have filed 2 reports in compliance with the order impugned in the present appeal has become infractuous. In view of the appeal, the being MAT number such and such. Madam, the show, madam, the trial judge ordered to give employment, not a particular post. Graduation, non-graduation, the beggar has no choice. My lord, they said that only the age bar criteria, the argument which was.
Mr. Bari, can we do this? We will ask Mr. Court to submit before us.
Yes.
That whenever they will be conducting a recruitment process in which your educational qualification matches, you will be considered.
Yes. No matter this point, madam, to that, my lord, I have no objection to that effect.
No,
but my lord, I tell your lordship.
No, your objection may be on this ground that when such process will
Yeah, yes,
be conducted,
yes,
when we
yes, my lord, in the meantime, age bar, he will be completed.
They will not raise the issue of age bar.
That is the only, that the trial judge order only the age. My lord, argument was advanced before the, I was there. Argument was advanced before the single judge. This for the age criteria they are not giving. Then the trial judge considered the issue.
Age bar issue I can't raise.
Then my lord, the lordship disposed of the matter. The age bar issue will not stand in the way.
My only grievance is that I will call him.
That is what I told Mr. Kaur. But today,
let Mr. Kaur have the instruction in this matter.
Mr. Bari, we are asking, suppose we do not find any wrong in the order. It has been Mr. Kaur's apprehension is that today, if you do not say that this post he is not eligible, that is why we not.
No. That point was adjudicated. the eligibility criteria for a particular post, I do
was
not have.
adjudicated.
That point was urged before the single judge.
That
Only
was not
Mr.
adjudicated.
Means I was there, Mr. Kaur was not there. I tell you, Lordship, Mr. Naik put the.
So,
took-
Mr. Kaur, if you pass an order, your authority,
Yes.
ask your authority to pass an order, this
In terms-
recruitment process we cannot consider because you do not have the,
Absolutely.
and in future, whenever a recruitment process will be conducted, we will
My
consider.
humble submission
My
before
lord will, my lord can,
Huh.
my lord can record that and dispose it of. And also record that if his eligibility matches with any post which is not going for public employment, we will call him. I'm making that statement.
My lord,
And
what-
lord, today, Mr. Bari showed your lordship's order. Today, my lord, I'm not challenging that order of 1st of March 2016. Lord, it is an implementation. The court never said that you relax the eligibility criteria and consider him. That the court did not say. Therefore, my lord, we will have to consider him in the appropriate post as and when, Lord, that post is announced. And Lord, in the report, your lordship will find we have categorized that those two posts.
No, that is the direction. Na? In such matter is referred sent to respondent number 3 to consider the prayer for pursuant to the previous order.
Of the honorable
But
court.
in which selection
Yes.
process it
It
has
has
not
not
been
been said so.
Previous order, but Lord, I have to consider him now, representation.
No,
That
no.
question is, I will consider his representation when his vacancy arises in the his eligibility criteria is fulfilled. That
Exactly.
kindly, that part only kindly.
That part you say in your order that in this case we have considered you don't have the qualification. We will call you in the next selection process where your qualification matches finished.
They,
Your lordship
they
can-
want some observation from
recording
the
my-
appeal court so that my lord, they
my
can shut
rec-
the door.
My
For
no,
the
no, no,
poor-
not
poor man.
no
Why,
question.
what is the illegality in the order? Court never said so, they given a.
Lord, kindly record my submissions and Lord dispose it of. Lord, I am trying to avoid, Lord, a further
But,
litigation.
but
I tell your lordships frankly, I'm trying to avoid any further litigation. Lord, this is not, Lord, worth the litigation. Kindly record my statement and dispose it of. That as and when any post, Lord, comes up for recruitment where his eligibility criteria mix.
Next selection process probably 5 বছর পর।
Or, Lord, I can file an affidavit.
Instruction নিয়ে নেন না। রিপোর্ট ফাইল করে দেন।
ইনস্ট্রাকশন কি দরকার? এই তো অর্ডারই রয়েছে।
কমপ্লাই করতে বলছে পয়লা এই মার্চের
Lord, I can file an affidavit.
Mr. Cod, you tell us now that next
Well-
recruitment process we are going to commence here.
Yes.
You will get your qualification tallies will finish because
Kindly record that as my submission. That, Lord, as and when, Lord, these posts, Lord, come up for recruitment, or your lordship wants, Lord, I can file an affidavit also to that effect.
as and when
From 2016 to now 8 years elapsed.
It's a public enterprise. Lord, the recruitment process has to be, Lord, decided by the board. As and when, Lord, vacancy arises, then only, Lord, the recruitment process can start. I can't, Lord, create posts. These are sanctioned posts where, Lord, I'll have to recruit him. This is not an ex-cadre post, Lord, any relaxation can be shown. He has to appear in a regular recruitment process. That is the observation of the court.
when did you start this process?
The
Recruitment process?
these recruitment processes in 2016. Your lordship kindly gives me a minute. That is there in paragraph 13, I think, in the writ petition, page 2930.
Paragraph 13.
I think, Lord, paragraph 13, yes. Kindly, Lord, come to page 29. Page 29, writ petition, Lord, paragraph 13.
Hmm.
Kindly turn the page. The second sentence. It appears from the information. Has your lordship got that?
1780. Page 30.
Page
It
30,
appears
top. 2017 and 18. And these are, Lord, post of executives where he does not qualify. And there has been no further recruitment drive therefrom.
Madam, the trial court simply said you comply the order dated 2016. So what's the wrong in it? They have not said so.
No,
You
there-
issue
there
the
is-
appointment letter tomorrow. The only the age bar, the point was taken before the single judge. Single judge clarified the issue.
So that
Now
is-
I am grateful to Mr. Kaur that he is not raising that point. Well, everything done. To show what is the scope of interference of the single bench
No, no,
order.
that is not the only
Court
point
didn't
taken.
say that you give the
71
appointment.
Page 71 and 72 of the report, that is also a point taken with regard to his eligibility, which is not been dealt with by the learned single judge.
I'm not claiming for a particular post. My land was acquired and the poorest of poor man. The single judge considered the same. The order was tested after 6 years. Order was affirmed by the appeal court.
But that
And
order,
that single judge only says that you comply the court's order in 16.
that
So what's wrong
that
with
is
it?
not the order. That order, 2016 order,
This order, Mr. Kaur, does not refer to this recruitment process also.
Yes.
nothing,
Nothing has been recorded.
nothing. That is what my worry. The problem is, Lord, it does not refer to the past recruitment process. It only says this portion is really troubling me. I tell your lordship. I just not want to point out that the learned judge, Lord, this consideration part, this consideration part is what is troubling me. Your lordships will see, it says, consider the prayer for recruitment of the petitioner. Number 2, pursuant to the previous order, within weeks, personal hearing to be petitioner. Such reasoned order, 2 weeks passing thereof. If the petitioner is otherwise found entitled, like a reserve category candidate, he should be immediately considered for.
Now-
Reserve category is not the criteria.
Which is the recruitment process you are referring to?
Recruitment rules, Lord, starts, Lord,
Hmm.
page,
One 12, on page 112, the name of the post has been mentioned.
The
It is
age limit,
admitted
it
to
is
the
admitted in the report on affidavit.
2010
Candidates who
recruitment.
applied for
হ্যাঁ,
consider that of the view.
এজটা নিয়ে তো কোনো গল্প-
85, Lord,
Well,
ki-
that is the only point Mr. Naik took that point. Page 112, your lordships kindly see
But my
the
learned friend just pointed out to your lordship that, Lord, also eligibility criteria was argued. I was not
No,
there.
which
No, no.
recruitment process you are?
2010. It has been, well, your lordships kindly see page 112.
No, no, just a minute. Recruitment rules your lordship wants to see. Page 85, Lord, is the recruitment rules.
32 years, and therefore he was clearly not eligible under the
Yes.
2010 recruitment.
Only this age criteria was taken.
Now, which recruitment process you are saying?
Lord, in the writ petition, his allegation was in
Now
2000
that recruitment process is
is
over.
over. Immediately, there is no recruitment process in contemplation. But Lord, under the rules, he is eligible for 2 posts. Those 2 posts, for those 2 posts,
You mention in the order, Mr.
no recruitment drive has been made.
So see, you say that in the order. This order is only for implementation of Justice Banerjee's order. And no court has not gone into this, that qualified, not qualified. Court has said you consider in the light of that judgment. Finished. Now when you pass the order, Mr. Kaur, you know better.
Lord, then it is better that we consider.
Withdraw the appeal or
No, no.
withdraw the appeal,
Lord,
we finish it up. Or we will say that there is no infirmity. Why do you want?
Lord, the question of consideration could come up, Lord, if we have done something which is contrary to the order. His second writ petition is for implementation of the order. If the court, Lord, is unless the court is satisfied that something, Lord, has arisen which requires my consideration so far as his application is concerned, court would not have passed this order.
No,
Question is today.
because your advocate did not point out that what is itching you is that suppose today our recruitment process is, we are going in that he is not qualified. We will be having a sword upon our shoulder to consider him for that recruitment process. That is totally misconceived. That is not the order of the court.
Lord, kindly clarify that and dispose it off. I am
Why
saying,
should we create a fresh right in your favor saying that
Lord,
your
no
officer
fresh
will
right.
be-
I am kindly, Lord, restrict my consideration in terms of the order of 1st March 2016. That is precisely what I say. I am not saying consideration strictly in terms of 1st March 2016.
1st March 2016.
16.
Page.
That
This is, that is, Lord, order, page 48.
48 থেকে।
that is the earlier order.
That is the earlier order.
That is what the court has said.
No, court says, Lord, his representation, fresh representation has to be considered. The fresh representation is only 2017-18.
Fresh representation in respect of the age bar.
Kindly come to page 114.
এখানে হচ্ছে বয়সটা কনসিডার করতে
Yes.
দ্য ডেট অফ দ্য ডিসেম্বর 30, 2007 হ্যাঁ সেটাতে ওনার এটা ঠিক করে দিও এই অফিসারটা চলে যাবে যে বয়সটা কনসিডার করতে হবে অন দ্য বেসিস অফ দ্য ডিসেম্বর 30th, 2011
December
30th, 2011 এই যে এইখানে আছে 114 বয়সটা এই ডেট অনুযায়ী
When the
that
first application
recruitment
was filed.
process has also not been referred to in the order, which you are saying.
Lord, I showed your lordship the grounds on which, Lord, the writ petition was filed. The writ petition is filed that we are trying to bypass the order. That is the reason why the second writ petition is filed. Otherwise, there was no cause of action for him to come to court. And I am saying, Lord, that that allegation per se could not have given him a right to sue. Because he was not eligible, he could not have come to court.
এটা এক্সিকিউটিভ TSH ট্রেনি
And Lord, on the age, Lord, I am not raising any.
TSH training, what is that?
OSH TSH within bracket trainee / OSH.
Kindly, Lord, see the recruitment rules. It said those both are, Lord, one is a both are class 4 posts. One is a non-technical, the other is technical. Please come to page 96. The last two, 27 and 28.
TSH মানে টেকনিক্যাল কি করতে হবে টেকনিক্যাল টেকনিক্যাল
Lord, even with regard to age and the weightage with regard to reserve category,
টেকনিক্যাল সুপার কি সুপার হ্যান্ড
support hand.
সাপোর্ট হ্যান্ড
Support hand.
টেকনিক্যাল সাপোর্টিং হ্যান্ড
Yes.
ট্রেনি and OSH মানে
Office support hand.
hand. That means a selection process was undertaken to fill up TSH trainee and OSH trainee.
Right.
Then the applicants offered their candidature for the post.
No.
No, he made application.
You made application.
No. There was no recruitment to that post
It is
2016.
admitted in the report on affidavit that the
Candidates who apply.
candidates who apply for post have an age bar of ato.
Only, my lord, then, your
Oh,
lordship
yes.
kindly.
Lord, I tell your lordship, what was misconstrued, your lordships may kindly come to page 51 in a moment. Lord, here, Lord, the court said, if your lordships kindly see the order of 1st March 2016 once again, page 51. Your lordships will find, here it says, kindly see the last 5 lines. The candidature of the petitioner's son in the relevant recruitment process will be considered by giving him weightage as a reserve category candidate with a maximum concession permissible under the rules. Age bar was not at all a direction. This was weightage with regard to his reservation being in reserve category. That weightage has to be given.
My lord, your lordships kindly have a look to the.
And the order also clarified,
In respect of age ছিল
if after all the petitioner's son is unable to qualify for appointment, nothing further need to be done.
My lord, your
Lord,
lordship.
age, that argument that was made, I am not, Lord, that's why I said that I'm not making that argument.
আপনি শেষ করুন আমি একটু বলি
eligible qualified to participate, সেই জন্য এই ইলেকশনটাই হওয়ার দরকার ছিল, আমি সেটাই বলছি।
Irrespective of whether the candidate is eligible for.
Madam, may I interrupt?
Yes.
Your lordships kindly have a look to the observation portion, page 114. 114. Not only the age relaxation up to 35 years should have been given to the respondent of petition number 2, but his candidature age limit on December 30th, 2011 should have been considered.
Point on each.
The restrictive interpretation given by the respondent authorities cannot render the honorable court's order nugatory. From the written instruction, your lordship kindly asked my learned friend to place the written instruction. Well, only the criteria age was taken at that point of time. From the written instruction dated April 25, 2030, handed over the court in today, it appears that the additional general manager considered the age of the petitioner to as on March 3, 2016. This court is of the view the date of application as on December 30, 2011 should have been considered by the concerned authorities since the prayer was originally made by the petitioner number 1 on that date. The view of this court finding. In such of the view of the matter, the respondent number 3 directed to consider the prayer for recruitment of the petitioner number 2 pursuant to the previous order of the honorable court in the bench 1st March 2016 within 6 weeks from the date after giving a personal hearing to the petitioner. Such written order shall be communicated within 2 weeks from the passing thereof. If the petitioner is otherwise found entitled like a reserved category candidate, he has to be immediately considered for appointment of the suitable post within 2 months. What is the wrong in it? They said only the open court. This is the written instructions. We are only problem the age bar.
They have filed a report, Mr.
Yes.
Wherein the qualification factor was
No. They only, my lord, pointed out the age. For the age criteria, we are not able to.
We understand
Yes.
that was the submission.
Yes.
What Mr. Cord is referring to is they have filed the report showing that in a particular selection process you are not eligible. Recruitment policy of 2010 you are
My
not
lord, if I am not eligible, what the learned single judge said, order of March was tested before the appeal court. It was not touched up by the appeal court, that it is binding upon all of us. To show my lord, the learned single judge said you comply the order of 16. They have not said that you give appointment today or tomorrow. He said taking in the age bar, treating on the December 2011, you consider it. Let them pass an order. Only that point was taken mind. Still remember before Justice Banerjee that we are unable to give. If your lordships clarify, concession is being given, we are ready to give appointment.
আমরা যদি টাচ করি না এখানে সব বললো কি
Maximum expenses concession permissible under the
সেটা তো ওনার আর্গুমেন্ট।
এজের ক্ষেত্রে ও বললো এসটি 5 বছর কম, এই জন্য এজেন্ট বলছে 5 বছর কমে 35 তিরিশ যদি লাস্ট হয় আপ টু 35 ইয়ার্স 5 বছর কম। সেটা 5 বছর দেবে না হলেও ডিলিট করেছে সেদিনের
এটা তো since the man the same should have been considered while considering this court is already pursuant to the should have been considered.
কটা বাজলো রে? দারুণ ঠান্ডা, এত ঠান্ডা না। কত 64 না?
Ashok, the present appeal has been preferred. যেখানে petitioner is qualified to apply, সেই জন্য ওদের কোনো jurisdictionই ছিল না consideration এর পাঠানোর জন্য। The present appeal has been preferred, challenging an order dated 25th April 2023, passed.
Yeah, I have my lord's kind leave, but there's a matter which is called in Chief Justice's court.
Yes. The present The present appeal has been preferred, challenging an order dated 25th April 2023, passed by the learned single judge in a writ petition being WPA 2654 of 2022. Records reveal that the present writ petition has been preferred. The present appeal has been preferred by the West Bengal State Electricity Distribution Community Company Limited, bracket A, insured WBACDCL, and its functionaries, challenging the order dated 25th April 2023, passed in a writ petition being WPA 2654 of 2022. Records reveal that the petitioner first approached this court records reveal that the petitioners first how many, there are more than one petitioner.
No.
One
The
petition.
father along with the son.
Oh,
The land was
first
vacant.
writ petition was by father.
Father and son.
No, first writ petition was father and son. No.
Let me check up.
Was by Jamiruddin only. Jamiruddin is the father.
Father.
In this order, it has been specified father, son also. In the order, it has already been petitioner's son. Already in the order, it has been specified.
No, both of them, in 16 March, your lordships kindly see the page 49 top. The petitioner's son attended the majority or about 2005.
সেটাই বলছি
Petitioner's son is the
no, at the initial writ petition, whether the son was there, that I can't say. Anyhow, the petitioner's son's reference was made.
petitioner's son is a Habib Ahmed.
Jamiruddin father.
Employment for Habib.
Yes, Habib.
Initially in 2016, Jamiruddin has taken the writ petition, and where it has been specified petitioner's son also. In the order itself, it reflects. That is on 1st March 2016.
that earlier writ petition is not here, Mr. Bari.
No. Only the order
has been.
order has been.
Only the order. records reveal that the petitioner number one earlier, there also two persons were there. এই যে জন- দুটো নেই দেখো।
One petition was taken out, seeking
Records reveal that the writ petition being WPA 2654 of 2022 was preferred praying for a direction upon the respondent stroke appellant's hearing. Little records reveal.
That the petition being WPA
Hmm.
was preferred, bring for direction from the current hearing.
To grant employment to the writ petitioner number stroke respondent number 2 hearing in terms of an order dated 1st March 26 passed by coordinate bench passed by 1st March 2006 passed in the earlier writ petition being WPA 2685 W of 2016. The said writ petition upon contested hearing, the said writ petition was disposed of by the order impugned in the present appeal, directing the respondent number এখানে
না এইখানে আছে না।
না না ওটা বলছি এইটা করেছি তো। ওটা দেওয়ার দরকার আছে ছোট করে দিচ্ছি ডিরেক্টিং এই পেজ 114 এ আছে হ্যাঁ Mr. Paul Learned advocate appearing for the no, ঠিকই ওইটা দিয়ে দেওয়া উচিত বলো একটু একটু কেটে দাও না as prefer function is challenging an ordered date records reveal that the petitioner that the writ petitioner stroke respondents hearing preferred a writ petition being WPA 2685 W of 2016 which was disposed of by an order dated by an order dated 1st March 2016. Directing inter alia that বলে কোট আনকোটে পেজ 55 টা দিয়ে দেবো হ্যাঁ এটা দিয়ে দেবো 51 সরি 51
এইখান থেকে এতটা
এই যে এতটা সরি ঠিকই বলছি এটা না পেজ 51 thereafter the respondents hearing again approached this court by a fresh writ petition inter alia praying for the implementation of the order dated 1st March 2016. Stop. The said writ petition was opposed by the appellant's hearing, stating that the respondent number 2 was more than 32 years of age on the date of his application and that he was clearly not eligible for the under the 2010 recruitment policy of the corporation. Stop. After contested hearing, the writ petition was disposed of by the order impugned in the present appeal, directing এবার কোট আনকোটে পেজ 114 থেকে 115 দিয়ে দেবে। Stop. Mr. Call Learned Advocate appearing for the appellant submits that no recruitment process has been initiated in which the respondent number 2 can be allowed to participate. No recruitment process has been initiated in which the respondent number 2 is qualified to apply. In view thereof, the learned single judge erred in law in relegating the matter to the respondent number 3 for consideration. Such argument of Mr. Cord is not acceptable to us. Stop. Is not acceptable to us. The court, the learned single judge, upon considering the rival claim, has directed the respondent number 3 to consider the prayer for recruitment of the petitioner pursuant to the respondent number 2 pursuant to the previous order passed in the writ petition WPA 2685 W of 2016, dated 1st March 2016. Stop. In view thereof, no interference is called for in the present appeal. Stop. Accordingly, the appeal and the connected application are dismissed. There shall, however, be no order as because urgent certified selection. Yes, next.
March order was duly affirmed by the appeal court, your lordship indicate. March order was duly affirmed by the appeal court, your lordship indicate that.
That was contained.
No. Order of the March, Justice Banerjee's order was tested before the appeal court. Appeal court confirmed the.
That is which page?
That is the page, bro.
আচ্ছা ওইখানে
Page 64.
ফার্স্ট অর্ডারটা কোট করেছো তো?
Page 64.
তারপরে একটা লাইন দিয়ে দেবে। Stop. The said order dated 1st March 2016, na? 1st March 2016.
Page 64.
It has been become infractuous, where it has been stated.
Was challenged by WBC, challenged by the appellant's hearing. Was challenged by the appellant's hearing.
Dismissed.
আমরা সেটাকে ইমপ্লিমেন্ট করছি যেহেতু
That is not required.
Yes,
Mr.
ma'am.
Bhatt.
Dismissed. It was dismissed.
It has become
Dismissed on the ground.
infractuous.
they
No,
came
your
up
lordship
with
can. The appeal
reports.
being MAT number
no
connected
point.
application sold number are dismissed.
You're reading the last line.
Yes,
So they are saying that we are going to implement.
yes, that means the. That
That
means
is
well,
why
no
we say-
interference was
And
called
hence
for.
appeal yes.
Yes, no interference was made by the appeal. That's why they waited 6 years for non-implementation of the order. Then, my lord, the appeal file in a second writ petitions, they will come.
In the order, there is no specification that the
Anyhow,
direct
but you
service is to be,
tested it before the
recruitment is to be given. He has to contest, he has to appear before the
After the
recruitment
filing of the
process.
second
So
writ
the
petitions,
an appeal was
In the
preferred.
appeal, they stated that they are going to implement
Implement
the
the-
order
Yes.
dated 1st March
Yes,
2016.
and through report has
And
been
hence
filed.
appeal court did in fact
Yes,
any order.
on the
Yes,
basis of
they don't,
infractuous.
implement it.
No,
intention of the appellant was not.
that's infractuous.
And
So,
now-
well, no
Now,
point.
Mr. Bari is seeking an observation.
He wants to take advantage of that.
The appeal has been dismissed.
What advantage you will take? You will pass an order after this that you are not eligible for this recruitment.
But
process.
I strictly
As and
remember
when it appears.
they
But
submitted,
that's a,
they submitted a
Yes,
report.
next. এই 12টা ডাকে। ও বাবা, difference. Yes, Dr. Baru.
My lord,
Ah,
my lord, I am for the respondent in this matter, my lord. Lordship.
Mr. Banerjee, we cannot take up my brother agree to it.
Lordship.
Bench.
Any date convenient to your lordship except 13. Any date convenient to your lordships.
Except Thursday.
No, except 13. Except 13. 13 is Wednesday. Any date suitable to your lordship.
You have a
resolution today, Mirror. That's the difficulty.
You have a resolution. চট করে দেখো না কি আছে করুন।
From 2 and onwards, you will not.
তাই জন্য এত আনন্দ দেখতে 21 তারিখ হ্যাঁ 21 তারিখ কি বৃহস্পতিবার?
Yes, lordship. Lordship, yes.
21 তারিখ তাহলে 3টের সময় পার্থের সাথে একটা বেঞ্চ
I'm much obliged.
First, we will be bench. We will indicate the time.
Lordship. Yes, lordship. Yes, lordship.
Humbly seek an appeal without the certified copy.
This is not it.
Grateful. Chalo. Order হয়নি তো।
My lord, I beg to appear on behalf of the petitioner, my lord, led by Mr. Subir Sannal. But it is that matter where
You people have adopted resolutions. What is the matter?
my lord, in respect of a 2018,
Now what happened? Affidavits have been exchanged.
my lord, I have received the affidavit in opposition and I have prepared my affidavit in reply served on the writ petitioner, the private respondent and all other parties. My lord, may I file my affidavit in reply?
All persons have filed their
Only the respondent number 1. The state respondents and others
have not filed. But let it be not today, it will be there in this time to get it.
My lord, only thing, I am enjoying an interim order which is there till 15th. So, my lord, if
15th, Monday we are 11th, it will be in the list without any caption of time. It will be taken up. 15th, up to 15th. Yes.
my lord, may I only trouble your lordship to, it's my prayer, if any time could be, my lord, if any time could be fixed.
Pardon?
If any time could be fixed, subject to my lord's convenience. Well, may I file my affidavit in reply or on that?
File on that date. এই শোনো কার্তিক এটার সাথে যে আরেকটু assignment এসেছে। লিস্টটা দেখে যাও তাহলে। ফোনে কল করে তো জানি নাকি। বাড়ি গেছে।
Twenty-two, my lord, I appear on behalf of the
Yes,
petitioner
Mr.
appellant.
Chakraborty,
22.
you had a bad case.
No, my lord. My lord, that case, my lord, I submitted before my lord. For the self-same offense, 8 persons were implicated in a criminal case, but I was taken under disciplinary proceeding and removed from service without initiating any disciplinary criminal proceeding against me.
Oh, this is not compassionate appointment.
No. Compulsory appointment, compassionate appointment, your lordship, my lord, before my lord, there are 2 or 3 cases. I believe very, very good case. I believe.
Acquittal or proceedings initiate now.
Whether there was the admission of the charges
this
on your part
22
at the time of giving reply.
Pardon, my lord.
Generally, employer does not initiate disciplinary proceedings if there was a admission on your part, or in criminal case conviction there is a conviction.
No, I did not admit any. Nothing was for my admission. Nothing.
Okay.
And my lord, only one thing, my lord. In this item 22, order was passed by my lord on 27 September. No order for filing paper book was given.
We filed.
In 20.
Our order.
Yes, my lord.
That is to assist the advocates that so that they can exchange their evidence, we can hear it.
Yes, yes. My lord, from the state petition, it can be placed. So, my lord,
my lord, Mr. Oniman with this appearing on behalf of the Union of People, my lord, he's on legs with the Honorable Justice Tapabrata Bhattacharya, my lord.
Come next. Come on the next date.
Grateful, man.
How can he be on legs? You people have adopted resolution. You know that he is in some other court, or you just submitted.
Yes,
you just submitted that he is on legs.
He is in court room number 9, my lord.
How do you know that he is on legs? You people have adopted resolution, you know.
Actually, I am
My lord,
just
Exactly.
come
So
now.
you have, just now you have come that don't say these things. When you don't know, tell the court I don't know. Don't make up and say something that you should not practice. But a junior member should not. Yes.
yes.
কত কেসে হয়েছে এসে বলেছে যে অন্য জায়গায় লোক পাঠিয়ে দেখে এসছে শয়তানি তো আজকে কম্বাইন লিস্টে কি ডাকে ডেকে দাও রেজলিউশন নিয়ে বাড়িতে আপনাদের কলকাতায় আর মামলা হবে কি করে
দিন বাড়াতে
ওই স্যাটারডে করে কোনো এফেক্ট nobody will strike the
district court
My lord, I am for petitioner.
দাঁড়াও
Mr. Achin Kumar Majumdar has not appeared. He has not come to court. Kindly not today.
yes ডেকে যাও এই এই যে কেদারের চক্রবর্তী দাঁড়িয়ে রয়েছে নমস্কার এই বহু মামলা আমি করেছি এর সাথে মামলা তো কম বেশি মামলায় না কার মামলায় অবিটা আমি একটু পরে পৌঁছেছেন পরে নিশ্চিতের সঙ্গে গল্প করে এরই মামলা ছিল
310, 312,
wastage of time
40 to 390. Three 321, 322.
My lord, and on a extreme compulsion, my lord, I beg to be excused to mention two matters, my lord.
Don't mention. Come on Monday.
My lord.
Yes, just now we have
as you. Yes.
Come on Monday.
My lord, grateful. My lord.